Hi, everyone. I'm Olivier Roth, Policy Manager at the SRA in the Innovate team, and I'm going to talk to you today about how the SRA can help your firm innovate with AI. And this session will have a specific focus on two resources that we're currently developing. The first one is a GenAI FAQ, and the second one is a best practice note on using sensitive data in AI tools. So as we all know, AI is increasingly transforming how legal services are delivered. Law firms are adopting AI both to help improve efficiency and cost savings in their back office functions, but also to streamline tasks, to deliver legal services, to interact with clients, and even to explore new business models. One example of this is Garfield, an SRA authorized law firm that helps small businesses and sole traders recover debts using GenAI, but with a solicitor still checking all of the outputs. And this shows how GenAI can open access to justice and reduce costs for consumers, but keep strong governance and oversight built in. At the same time, consumers are also turning to AI tools directly, sometimes for basic advice, sometimes for document support. And the opportunity is huge as well. Better access to justice, improved consistency, reduced costs. But with these opportunities, there are some risks: hallucinations, confidentiality breaches, and the challenge of maintaining public trust. So the first resource I'm going to talk about is the GenAI FAQ. We've developed this to respond to consistent questions that we hear on a regular basis from solicitors and law firms about how GenAI is or should be used in legal services. The FAQ is designed to give a baseline understanding. So what GenAI is, how it's being used, and the regulatory ethical considerations. This is not meant to be prescriptive, but rather supportive guidance. And we know this will need updating regularly as the technology and its applications continue to evolve rapidly. The FAQ is organized around 6 broad themes that try to map the GenAI journey of the solicitor or of the law firm, from scoping to procuring to implementing. Now, the first of these themes is the research and decision making. This section is meant to help firms and individuals scope out what kind of GenAI tool they might need. It signposts to existing resources and sets out some practical questions to ask vendors, such as who developed the tool, whether it's been tested for England and Wales, and what its limitations are. The second theme is implementation and integration. Here, the focus is on how to embed GenAI safely within legal practice. It looks at issues such as having an AI policy, training staff, setting boundaries for acceptable use, and ensuring appropriate human oversight of outputs. The third theme is data protection and the use of client information. So this part explains the risks around confidentiality, privilege, and why client data should not be used to train models or entered into public tools. It links to our separate guidance on handling client data, which I will talk about later, and it underlines the need for anonymization, client consent, and compliance with data protection law. The fourth one is regulatory approach and compliance. In this section, the FAQ clarifies that the SRA regulates solicitors and firms and not the technology itself. It explains how we monitor the use of GenAI in legal services, how concerns would be addressed, and what obligations remain with the firm or the solicitor, regardless of the tool that they adopt. The fifth one is around consumer protection and ethical considerations. So this section sets out the risks for clients and the responsibilities firms and solicitors have to avoid misleading clients. It underlines the need for clear disclaimers, transparency about the limits of AI and GenAI, and oversight so that consumers are not exposed to harm. And then the final theme is around transparency and explainability. The FAQ stresses that clients should be told if GenAI is used as part of their service. And explainability matters too. So solicitors should be able to understand and, if necessary, explain how the AI or GenAI reached its output in order to maintain supervision and client trust. Next, we move on to the key messages of the GenAI FAQ. So I think the first one is that firms remain responsible for the output. The FAQ makes clear that using GenAI does not reduce or transfer responsibility. Solicitors and firms remain fully accountable for the quality, the accuracy, and the appropriateness of the advice and services that they deliver, regardless of whether GenAI is a part of the process. The second one is that GenAI should be used as a support, not as a substitute. GenAI should be seen as a tool to support professional judgment, but not a replacement for it. It can speed up research, it can help with first draft, and it can improve efficiency, but human review and supervision are essential before anything reaches a client. The third key message is around risk, whether it's around inaccuracy, bias, or confidentiality breaches. The FAQ highlights the main risk that we've heard from the profession: hallucinations and inaccuracies, potential bias in outputs, and concerns about confidentiality and privilege if client data is used inappropriately. These risks can be managed, but only with the right safeguards in place. And then the final one is transparency with clients is essential. If GenAI is being used in a way that affects the service a client receives, solicitor must explain that clearly so that clients understand the nature and the limits of the tool. This helps maintain trust and avoids any risk of misleading clients. Next, we're going to move on to our second resource, which is handling client data in AI tool. Now, this best practice note on handling client data was developed because we have consistently heard questions from the profession about how to navigate professional obligations in this area. The use of GenAI is expanding rapidly across legal services, but there is particular uncertainty about how existing duties apply when client data is involved. So the purpose of this document is to clarify how the standards and the regulations, but also common law obligations and data protection laws apply in practice when firms or solicitors use GenAI that processes or interacts with client information. It is intended to provide reassurance to solicitors and firms by showing how established duties remain the starting point, even in a new technological context. The note also reflects on good practice that's already emerging across the sector. By capturing this and setting our expectation, it helps to create shared standards that support the safe and compliant innovation. This is important for protecting client trust, which underpins the solicitor-client relationship, and for ensuring that the use of GenAI strengthens rather than undermines professional obligations. So the core principles of this best practice notes are that no identifiable client data should be inputted into a GenAI tool without informed consent. The guidance makes it clear that identifiable client data cannot be entered into AI tools unless the client has given informed consent. This means explaining to the client what data is being used, how it will be processed, and what role the GenAI tool will play in this service. The second core principle is that you should never input raw client data into public AI tools. So free and consumer-facing tools such as ChatGPT or Gemini are not appropriate for client data. They do not have the contractual safeguards required under data protection law, and using them could breach duties of confidentiality and privilege. The third core principle is to anonymize data where possible. So where firms want to experiment with GenAI, they should try and use anonymized data. The anonymization should be effective, it should be documented, and it should be irreversible so that no individual can be identified. This helps reduce risks and maintain compliance. And the final core principle is to apply human oversight to all outputs. So all outputs that involve client information must be checked by a human. AI, GenAI, are never a substitute for legal responsibility, and solicitors must always retain accountability for the final advice or for the service provided. But the note also highlights some good practice. For example, conducting and recording risk assessment. So before deploying a GenAI tool that processes client data, firms and solicitors should assess the risks. This includes looking at what data is involved, how the tool is being used, and whether safeguards like consent or anonymization are in place. Another good practice is maintaining audit trails of GenAI use. So firms should be able to demonstrate what data was processed, by whom, and in what context. Logging GenAI use and keeping records of decision supports both compliance but also the client trust. The third good practice is around governance, so having registered policies and training. So this can include keeping a register of GenAI systems in use, setting clear policies on when and how they can be used, and training staff so that they understand the limits. This also helps embed accountability and avoids misuse. And then finally, it's to match the safeguard to the tool used. So different tools, different GenAI tools carry different risks. A secure in-house system will require a different approach compared to a public model. So firms and solicitors should match their safeguards and contractual checks to the type of tools in question. In the best practice note, we've also got some examples of good practice. So one, for example, is a sandboxed AI for drafting. So we had an example from a mid-sized firm that built a drafting tool using an API configured with a retrieval augmented generation or RAG system. All the client data was anonymized and it was kept within the firm's secure environment with a human review before the outputs were used. We've also heard of an immigration firm deploying a chatbot to help new clients identify the right visa route. The tool was clearly labeled as GenAI and it collected only essential details. And it also gave clients the option to skip the tool entirely if they preferred. We've also heard from a national firm that created an AI ethics group, kept an internal register of the GenAI tools being used, and trained staff on when and how GenAI could be used. This included strict bans on inputting data into public tools, for example. And then finally, we have the case study of Garfield. So Garfield is a debt recovery law firm powered by GenAI and authorized by the SRA as a licensed body. It demonstrates how innovation can improve access to justice when it is deployed with strong governance, data safeguards, limit on automation, and a solicitor reviewing and checking all of the GenAI outputs. In conclusion, both of these resources, the Generative AI FAQ and the best practice note on handling client data in GenAI tools, are still in draft form and will continue to develop as the market and the technology evolve. They are designed to provide practical support to both firms and solicitors who are already starting to use GenAI, as well as to those who are considering it. The central aim is to help firms and solicitors adopt GenAI tools in a way that is safe, compliant, but innovative. The resources show that while the technology is new, the underlying professional duties remain the same. Confidentiality, acting in a client's best interest, and maintaining public trust are as important in the context of GenAI as in any other part of the legal practice. By following these resources, firms can use GenAI to improve efficiency and access to services, while also embedding the safeguards that protect the clients and uphold the integrity of the profession. We will continue to refine these materials in light of feedback and emerging practices, and we welcome comments and engagement to ensure the resources meet the need of both practitioners and the general public. Thank you very much. And for further updates, you can get all the latest news and law tech development from us.